Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, Brandy Thompson from the Kronzig Firm, and Mary Chartier from Chartier Nyam Fukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome back to In the Name of the Law, a legal talk show about real people and real legal problems. In today's episodes, we're going to talk about COVID and the criminal justice system, Michigan's new auto law, and the process for CPS cases. Stay tuned.
In the name of CPS Defense and Family Law.
We're back with Brandy Thompson, who is a CPS defense attorney in Lansing. Now, CPS cases seem kind of confusing. Do parents usually understand where they are in the process?
Lisa, I think that is very prevalent through the calls that I get on a daily basis, that parents really do not understand the CPS process. One of the questions that I ask when I talk with potential clients or parents on the phone is where they're at in the CPS process. And almost always they're not sure. They cannot tell me whether they've had a preliminary hearing or they're set for pretrial or even a trial. And even sometimes they're not even sure that they've actually gone through a trial. So I think it's very important as a parent going through this process to understand where they're at and what to expect as the case proceeds through the court system.
Okay, so let's start at the beginning. How does a CPS court case get started?
A CPS court case is started by the filing of a petition, and that petition is initiated by a CPS investigator.
And what are the requirements for the CPS petition?
So the petition does have statutory requirements. Of course, they need identifying information of the people involved, the parents and the minor children. But it also has to state the specific allegations against the respondent parents or parent. And those allegations have to meet the statutory grounds for child abuse or neglect under the juvenile code. They also have to state whether or not one or more of the children have any type of Native American tribe affiliation, because different rules might apply in those circumstances. It definitely has to state what CPS is requesting. If they're simply asking for what we call jurisdiction, which is allowing the court to make orders regarding the family, order them to do certain services, or if they're actually going that next step and also requesting termination of parental rights. And then finally, the petition also has to be under oath or verified by the CPS worker that all the statements in there are true to the best of their knowledge.
Can you tell me a little bit about what happens at the preliminary hearing?
So the preliminary hearing is required if a child is already placed out of the home. In that case, it's required within 24 hours. Or if they're requesting that the child be removed from the home, that preliminary hearing is required. And at that hearing, the prosecutor would have to prove by probable cause that one or more of the allegations in the petition are true by probable cause, which is a very low standard when it comes to legal burdens of proof. But a preliminary hearing is not required in all cases. If CPS is merely requesting the court put some orders in place for the family, but the child would stay in the home with the parents, they do what's called a preliminary inquiry, where the respondent parents aren't entitled to be at that hearing. It's a very informal review. Typically, either a referee or judge will look at the petition. If it meets the requirements that we just talked about, they can authorize that petition, meaning the case will move forward without any type of hearing.
So just to confirm, a child can be removed from the parent's home before there's ever any kind of court hearing. Is that what you're saying?
That's correct. Typically, that is done on an emergency basis. If there is some emergency that the police or CPS see necessary to remove the child from the home, the child could be removed. But again, that preliminary hearing would have to be held within that 24-hour period after the removal.
So the preliminary hearing is to show probable cause. Does CPS have to prove every one of the allegations that they make in their petition?
No, often The CPS petition will have what I would call a laundry list of different allegations. In many circumstances, they will basically throw everything but the kitchen sink onto that petition, and anything that they see would be abuse or neglect, they put onto that petition. But at that preliminary hearing, they are only required to prove by probable cause one or more of the allegations. So it just takes one to get the case to proceed forward to that next step.
So I think just for a second, I think it'd help to talk about some examples, like if somebody is being accused of abusing a child, some of the other things they might add into their petition, like I've seen, and maybe you can give some examples, a dirty house, for example.
Exactly.
Or not having enough food in the fridge, or give us some other examples of what you've seen in petitions.
Yes, the investigation might be initiated by some, for example, an allegations of physical abuse, but as the investigation proceeds forward, CPS may talk with some type of collateral person involved in the case and find out maybe their medical, is not up to date. The child hasn't been to a doctor in 4 or 5 years, or a dentist. They're missing a significant amount of school. So they will add those additional allegations onto the petition, aside from maybe the first initial allegation that brought CPS into the purview of the family.
So once CPS demonstrates there's probable cause for one of the allegations of the petition, is that when the petition is, I think the term is authorized?
Yeah, that's correct. So the petition would be authorized, meaning the court does find that probable cause has been met, and the case will proceed forward. Typically, the next step was they would set a hearing date for a pretrial, and then ultimately a trial.
And did you say that there was a time period for that?
So there are time periods set by the state of Michigan. In cases where the child is placed outside of the home, we were talking about removal. If the child has been removed from the home, that trial should be set and is required to be set within 63 days. If the child is still placed with one or both of the parents, then the trial needs to be held within 6 months. That being said, there are exceptions, especially right now in the age of COVID. The court can delay that for good cause, and we can go past those 63 days. Often that happens in cases where there is extensive information that needs to be discovered. We need, if there are fractures and we need to do some research and locate some experts, that type of thing, we will go beyond those time periods. And certainly right now, with courts being unable to hold jury trials, they have found that has been good cause to delay trials currently.
So in some cases that you see, do you have a sense about what percent of them have the children removed from the home versus how many of them are with children that are allowed to stay in their parents' home?
Certainly, I probably have a bit of a skewed idea because the people that are calling my office certainly are those probably more of exigent circumstances, meaning they are the ones that have had children removed from the home. I know on the grand scale, those that are removed from the home, those are much smaller, a much smaller percentage of cases than the cases that I see. Of course, the ones that I see are more serious, and so I see a lot more of those removed. So I'm not sure if I have an accurate depiction of what the average person coming into contact with CPS would have.
So we don't have time today to talk about a trial and appeal, but will the parent get parenting time while all this is going on?
It depends. In some cases, yes. If they are not required, the court is not required to allow parenting time if termination has been requested by CPS.
All right. Well, thank you, Brandy.
Thank you.
In the Name of CPS Defense and Family Law is brought to you by the Kronzak firm. In the Name of Personal Injury Law.
We have heard about big changes being made to our NoFault Insurance law. We've had Steve Sinus from the Sinus Dramus Law Firm on a few times to explain these changes to us. Steve is back here again today to help us further understand our rights under the law. In particular, we are going to focus today on your rights if you are injured in a crash that is caused by someone else's negligence. Steve, it's great to have you back.
It's great to be back. It's been really good trying to educate the public about this complicated area of law, and I'm looking forward to the opportunity to do more of that here today.
So, Steve, if I'm injured in a crash that is caused by someone else, do they have to pay for all my vehicle damage?
As an attorney, this is a conversation I have with people, and they're really surprised about the outcome. And the reality is that the law says the at-fault driver is only liable for up to $3,000 of your vehicle damage. So if it's a really serious crash and the vehicle damage is $10,000, the at-fault driver only has to pay $3,000. You then have to turn to your own insurance coverage, the coverage you buy in the form of collision coverage, to pay the rest of that vehicle damage. So that's a surprising result for people that I talk to after a crash.
So if I'm injured, does the at-fault driver have to pay my medical expenses?
Okay, so the way to understand this is that the at-fault driver now, under the new laws we have here in Michigan, and really effectively this last summer, at-fault drivers can be held liable for the medical expenses of an injured person that are not covered by NoFault Insurance. So the way this puzzle comes together is that now under the laws, people can buy less than lifetime medical expense coverage on their NoFault insurance policy. So they used to have to buy lifetime expenses. That meant they couldn't sue the at-fault driver for their medical expenses because they were already covered under NoFault. Now people can buy these limited policies. So if you are one of those people who buy a limited policy, your medical expenses are limited to that amount under your NoFault coverage. And then you can turn to the at-fault driver for your uncovered medical expenses. The thing I want to point out, though, is that means that all of us can be held liable for each other's medical expenses. That was not a reality under the old form of the NoFault law we had here in Michigan. Now we must all understand that there is this reality where we can make a mistake and somebody could be catastrophically injured and they can sue us for millions of dollars of lifetime medical expense coverage. So we need to buy liability insurance, and a lot of it now under these new laws to protect ourselves from those type of situations.
So what about damages for pain and suffering?
Okay, so if you're injured in a crash and it's someone else's fault and you're experiencing the pain and the suffering and all the loss of quality of life aspects that come from your injuries, you may be wondering, how am I going to get compensation for this? And the answer to that question is that you can pursue compensation from an at-fault driver, but you have to sustain a serious injury. And the law has a definition of what's a serious injury. It includes death, and then there's this other term, permanent serious disfigurement, which covers amputations and serious scarring. But most cases fall under the definition of serious impairment of body function. And the law requires an analysis about whether somebody was objectively injured in such a meaningful way that affects their general ability to lead their normal life. And there's a bunch of case law that deals with that standard. What the viewer should understand is that if you are injured in a crash caused by someone else's negligence, it's not necessarily the case you can pursue pain and suffering damages. You have to have a serious enough injury that passes those legal standards to have that right. And if you can't pass that test, you don't have that type of claim.
So if I'm injured and I either can't go back to work for a period of time, or maybe I have to work a reduced schedule, who pays for that?
Okay, so going back to the idea of a puzzle here, NoFault insurance is part of the puzzle if you're injured in a crash, and your NoFault insurance coverage includes income loss benefits known as work loss benefits, but there are limitations to that coverage. It's supposed to cover the loss of income you would have earned if you were not injured, but it's capped at 85% of your gross income, and there's a statutory cap of $5,700 a month. So if you made more than that, you're going to be only subject to the cap amount from your NoFault insurance coverage. Bottom line is, whatever income loss you sustain that's not covered by NoFault insurance, you can pursue against the at-fault driver. But I want to make this point about the whole issue about suing the at-fault driver. There are insurance limits that everyone has. And so if you're at fault, you're going to be facing a situation where you need to know what kind of coverage that at-fault driver has. And if they have very limited liability insurance coverage, you may not be able to make much of a recovery. And that's one of the harsh realities of these at-fault driver claims. What were the insurance buying decisions of the at-fault driver?
Okay, so if I'm the at-fault driver, if I'm the one that made the mistake and caused the accident, what rights do I have?
Okay, and put this, back in the big picture, we have NoFault Insurance, and the idea of NoFault Insurance, that medical expense coverage, that loss of income I've talked about, is that these are benefits we get from our own insurance company, and it's payable regardless of fault. That's why we call it no fault. So if you are the at-fault driver, you still get those benefits, but you don't get the pain and suffering claim. You don't get the income loss beyond what's payable under no fault. So without an at-fault driver, you're going to be limited by what your no-fault insurance coverage provides you.
Well, and to understand the comparison, under the previous law, even if I was the at-fault driver, I could still get those benefits from my own insurance company, but now I can't?
Well, this gets at the issue of no-fault insurance buying decisions. So we talk about the decisions of the at-fault driver for liability insurance, which is the coverage that covers people's mistakes. No-fault coverage is there so that we have coverage for us as people when we buy our own policy. And when you buy a less than lifetime policy under the new law, you are in a situation where maybe if you're at fault, or there's nobody at fault, it's black ice, it's a deer that jumps out in front of you, you are going to be subject to those limitations. Under the old law, everybody had lifetime. So in the deer cases, in the black ice cases, they always had lifetime medical. Now, if you buy less than lifetime, you could be facing harsh consequences of no full coverage for your injuries.
Okay, great, Steve. Could you help us by giving us your top tips about what we should consider and look at when we're buying our own auto insurance?
So we have a graphic on the screen, and this helps summarize what I'm about to say. But let me put the puzzle back together for you. You have no-fault insurance coverage. Those are benefits that are payable to you if you're injured, regardless of whether you're at fault. They include your medical expenses. They include loss of income. The new laws allow you to buy limited medical expense coverage, meaning less than lifetime. We recommend you buy lifetime because the limited coverages inherently are limited. And if you're catastrophically injured, you're going to need way more than $250,000, way more than $500,000. So lifetime no-fault coverage. And then you should also buy a lot of liability insurance, because this new reality is that you could be sued for millions of dollars of medical expenses. So your business, in terms of the vehicles it insures, everybody out there has this new liability. So you have to increase the liability insurance limits. And then I'll also make the recommendation of uninsured and underinsured motorist coverage. That's coverage we buy ourselves to protect ourselves in the event we're injured in a crash with a driver who doesn't have insurance or enough insurance. So you have all these damages you can pursue against the at-fault driver, but what if there's no insurance? The answer to the question that you want that to be is that you made the right decision and bought uninsured and underinsured motorist coverage, and you bought a lot of it. That means your insurance coverage or your insurance company has to step in the shoes of the at-fault driver and pay you the claim as if they were them. That's why you buy that coverage, and you should buy a lot of it. So those are my recommendations.
And do all of these coverages that we now need to protect ourselves, are they going to cost a lot more than what we were paying previously?
The reforms are passed with the idea that they're going to lower our rates. I would suggest that to the viewers that what's going to happen is that in order for you to have the coverage you want to have that best protects your family, insurance coverage is not going to cost less. It's going to maybe cost more.
Well, thank you, Steve, for this informative session. We really appreciate it.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Criminal Defense.
COVID-19 has taken a tremendous toll on our nation and the world, but we're continuing to see it ravage those who are incarcerated in our jails and prison. So, Mary and Takura, let's talk about your experience with this. What's the effect on those in custody as well as the people who work in those jails and prisons?
There's a real physical impact on people who are incarcerated and the people who work in jails and prisons. So as of early September 2020 in Michigan alone, there have been over 5,000 prisoner cases and 69 prisoner deaths. There have been over 448 employee cases and 3 employee deaths. And then if you look federally, so those are individuals who are in federal custody, there have been over 13,000 federal inmates and 1,600 staff who've tested positive, and there have been 118 federal inmate deaths and 2 Bureau of Prison staff members who passed away. And those are astronomical numbers. The American Medical Association published a paper which talks about it. I believe it's 3 times people who are in custody are more likely to pass away from COVID, and there are 5.5 times more likely to get COVID. And those numbers you see are just skyrocketing. Even when there is a dip in the general population and the COVID rates, you're not seeing that same dip in prisons and jails. And that's because of the way they're set up, right? It's not necessarily that anybody's doing anything wrong, although I certainly can't speak to every jail or individual prison, but they're not set up to deal with a pandemic like this, where you can't socially distance people. You can't have people washing their hands, using hand sanitizer. We know that it is aerosol based, and that's becoming more and more studies are supporting that. So ventilation is really important. So prisons and jails can't follow the rules that they need to in order to keep their employees safe and the people who are there.
So, Takora, you sit on a statewide task force to look at jail and pretrial incarceration. Was this started before the COVID hit our country, and what was the purpose of the task force?
Yes, the task force, we began our work before the pandemic hit the world. Despite a decline in crime nationwide, jail and prison populations were going in the opposite direction, and not just gently, there was a steep rise. So we took a look at our populations in MDOC, the Michigan Department of Corrections, and each of the county jails. And there once was a time when people said, oh, it's in the urban areas, the heavily populated areas, but actually there's been a greater increase in the rural counties. So I think for that reason, a lot of the conservative politicians started paying more attention to this. And I think that's been a big reason why, for example, on the 9th of September, we issued several recommendations, and 5 of them received a hearing on the morning of the 9th of September. And within a week, we expect the remainder of the recommendations to receive a hearing as well. But it was to see what we could do. What is it about our laws in Michigan? Are we over prosecuting people? And of course, if there aren't laws on the books that open people up to prosecution and jail and prison time, then that's one way to fix it. So we endeavored to, of course, keeping at the forefront of our minds the victims, family of victims, and so on, but just to make it a more equitable system, and just to see what we could do about decreasing the MDOC and county jail populations.
So regarding the task force recommendations that are most relevant to these COVID times, is it just the reduction of population, or is there something more specific that relates to what we're doing now?
Sorry, but there are more. However, I will add that when, certainly in Ingham County, without a request from anybody, the sheriff, he sat down and several judges said, look, we're going to release people, right? And several other sheriffs did this in many counties. So I think people began to take a long, hard look at why people are in jail in the first place. And if something should be a civil infraction or not be on the books at all, then why are people spending time? And if sheriffs release people on their own accord, then that suggests to me whatever it is that landed them in jail in the first place probably shouldn't be on the books. For example, being a minor in possession. There was a time, I think as recently as 3 years ago, when the first instance of that would open somebody up to a misdemeanor conviction. However, now the first instance is a civil infraction. So, I mean, we don't have enough time to cover all the recommendations, but again, the fact that sheriffs release people on their own means that people are taking a long, hard look at why people are in jail and prison in the first place.
So it does sound like people now are being released early. And is it being also due to COVID?
Certainly. Oh, yes. Absolutely. Jails and prisons are incubators. You cannot socially distance. And again, the healthcare systems in prison, if you can call it that, they're not the best at all. So yeah, they're just not set up, as Mary said, for a pandemic of this nature.
Can we talk a little bit about how the difference with federal prisons and people being released?
Sure. So in federal prison, there are two mechanisms where people are being released because of the pandemic. One is compassionate release. And so essentially for that, I mean, it's a complicated area, but you have to have extraordinary and compelling reason. So there's got to be a health condition. Can't just be, hey, I want to go home. And so that's usually the main one. And then you have to request the warden release you. Frequently the warden says no, and then you can go into court. The court will look at the safety of the community and then the sentencing factors that all federal litigators like Jakura and I are really familiar with. And then you also can be released in from federal custody because the Attorney General wanted the Bureau of Prisons to look at people who are coming to the end of their sentence that's for a nonviolent crime. And so there has not been as much movement with that as I think people hoped. In state court, I think the hope was that the governor would engage in more commutations, and that starts, of course, with the parole board, and look at, do people really need to be in prison? When, as Jakura said, when sheriffs on their own accord are releasing people, was the sentence, did it need to be so onerous in the first place? And it's the same in federal prison, and it's the same in state prison. Do we really need folks to be serving this entire sentence? And, you know, when you think about the United States is 4.4% of the world's population, and we have in prison, I think, 22% of the world's prison population, right? So, I mean, there's this vast disparity, and you would think, well, are we safer? No, we're not safer. When you look at how the countries rank, we're right in the middle. I think the last time we were 65. So we need to be doing things differently, and I think that people can be advocating for changes in the law. People can be advocating for the parole board and the governor to look at commutations really seriously, and legislators to look at sentencing practices. There's a lot that people can demand of their elected officials.
Well, thank you. Jakura, Mary, you've given us a lot to think about how we can help change the system.
Thanks, Lisa. And we host a podcast called Constitutional Defenders on every platform that podcasts are hosted on. Please check us out.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC.
Thank you for watching In the Name of the Law. We look forward to seeing you next week for another exciting episode.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.